heating room of the house, so to dry out as quick as possible. But you can smell the paprika in a massive amount, even on the top floor of the house. So it was a very special period when some people might use perfumes or so, but we had paprika in the house. But it's something very special. For those who are joining the session, Steve is very nice to show the paprika to you, but we are always proud to say two things. Szeged is simply very famous of paprika. So there are a couple of regions in Hungary where paprika is produced in a massive amount. But this is just an issue. I mean, that's just like, where do we have more gold or steel or things like this? Useless. But we always say another story about paprika. This is a vegetable that was used to discover vitamin C. A person called Albert Szent-Györgyi, or St. George, I mean, it's a very hard name to pronounce, who used to be a professor and later on the rector of my university, invented vitamin C, and he's the only Hungarian person to have Nobel Prize for his work in Hungary. We have more than a dozen Hungarians, but all the others, I mean, used to work in the United States. But this actually including some people who invented hydrogen bomb, so very bad stuff, but nevertheless. But this guy was working in Hungary. Later on, he was also working in the United States, but after the Nobel Prize, by the way. But the story is very interesting. So he was trying to find this vitamin, and he couldn't simply find any vegetable or I mean living existence that included a significant amount of vitamin C naturally. Mm-hmm. And then on one of the hard days, he went home at around 9 p.m. His wife gave some dinner for him, sat down. As typically, I mean, Hungarians eat a lot of meat, why not? And bread, and it's quite typical for us to have, vegetable paprika to eat next to the bread as a sandwich. Then he sat down to the table and started to eat, and this tastes good. It's a fresh paprika. Where did you get it? I got it on the market, his wife said. And then he said, wait a minute, I never tried paprika, whether it has vitamin C or not. So he rushed back to his office. He tested paprika until within a couple of hours, so far after midnight, he found out that this is an extremely rich vegetable in vitamin C's. And in a couple of days, he could actually invent the process how to extract vitamin C from this kind of vegetable or other. So it's very interesting to say that paprika is very tasty, very good, but is the vegetable which is the vegetable behind vitamin C, and the only Nobel Prize of Hungary, which is from my university. And to tell the truth, and after that we can continue working with artificial intelligence as well. Of course, these are just these periods when people say fighting against the COVID is an extreme issue. But you might have heard that there are plenty of vaccines, and one of the vaccines was invented by a corporation. Well, we have to be careful. Pfizer BioNTech had the technology to massively produce one of the vaccines, and that technology is based on a specific research procedure made by a Hungarian lady called Katalin Karikó, who was, by the way, working at the University of Szeged before she found out that she needs more than Szeged. She needs her own place to work, and so she literally escaped the country in the 80s because that was still the socialist era. He settled at the University of Pennsylvania, and later on, by the way, one of my high school, not classmates, but year mate, so a guy from the same year, who studied also at the University of Szeged, we contacted her. He does it in every interview nowadays, that back in 2011, he contacted Professor Karikó, whether she would be too kind to help him in his future research. And by the way, this is the guy who officially and first reported on a stable mRNA technology. And so it's very interesting to say that the world is extremely small. You might know people within a few steps, as some of the Hollywood actors, including Kevin Bacon, told it once. I most probably know everyone from Hollywood because I have worked with some or many people in Hollywood, so I know I can contact everyone. And this is somehow true. So in 2 or 3 steps, you can contact a Nobel Prize person quite easily. I could contact in 2 steps Barack Obama, but it's stupid because I don't know Barack Obama. But it's just a very funny thing that I know some people who know him, and that's all. I know some people who used to know Franklin Delano Roosevelt as well. So you can imagine how old that person is. Nevertheless, I don't want to waste your time here. So I give the floor to the organizers to officially launch the event.
Yes, thank you. We may start, Bishwa?
Yes, ma'am. With your permission, let me take clue from Professor Stephen Barnes. He always says it's the safest way to greet any person with the Indian way. Namaste to everyone. And I welcome you all to this International Teaching Month, which we are celebrating for a month, to learn from the experts from across the globe. And for this session today, we have Professor Dr. Peter Mezei from Szeged University. And to officially welcome Professor Peter, I would request Professor Dr. Purvi Pokhariyal, the Director and Dean at Institute of Law, Nirma University, to please welcome Professor Peter.
Thank you, Bishwa. So I, on behalf of faculty colleagues and students and the management, welcome Dr. Peter. It's great to have you with us during this International Teaching Month. We have been, deliberating about your visit for the last couple of years, and probably at least we could meet virtually this time. And we look forward to your visit physically on the campus in near future. The topic that has been chosen by you is very, very relevant, and it's it generates a lot of interest. I could see so many lawyers joining for the session today, and that shows how eager we all are to listen to you. I'm not taking much of your time, but I welcome you to the campus and looking forward to your talk. Thank you. And welcome, Steve. Thank you so much.
Thank you, ma'am. And I would just take a couple of minutes, Professor Peter, just to formally introduce you to the audience. Professor Peter is an Associate Professor of Law and Associate Dean for International Affairs at University of Comparative Law and Faculty of Law, University of Szeged. He is a part-time faculty member of the College of Law, University of Toledo, United States, and also a visiting professor at University of Lyon at France. His courses include comparative law, comparative copyright law, and digital copyright law. He has prepared the national report for the 18th International Congress of Comparative Law in 2010 on the limitations and exceptions in Hungarian copyright law, and also the national report for the 19th International Congress of Comparative Law in 2014 on licensed contracts, free softwares, and Creative Commons. Before I hand over the mic to Professor Peter, just a small announcement, because this session was supposed to be shared by Shri G.R. Raghavender, who is the Joint Secretary with the Ministry of Law and Justice, Government of India. But because of some last moment parliamentary commitments, he could not make it to the session, and he has sent his sincere apologies for that. Now, for the audience, one small request, please keep yourself on mute throughout the session. And if you have any questions for Professor Peter, you can direct that to me through the chat box, and I would read out for the convenience of Professor Peter. And over to you, Professor Peter. I would not take more of your time.
Okay, thank you very much for the introduction. And I always feel myself a little bit shocked when people speak about my CV. I usually sum up my CV very shortly. I do my best to deal with interesting topics. And I'm very happy that some people find artificial intelligence, copyright law, comparative research interesting. So it's my pleasure to be here. And I must also say that this is probably the greatest shocking number of audience I have ever talked to. So we have more than 200 people. I appreciate the chance to talk to so many people interested in this topic. Let me also thank Steve for building the bridge here, but also especially for something. It's probably 3 a.m. in the United States at the very moment he's awake. So he either never sleeps or he's too kind to wake up and listen to this presentation here. But without further ado, let's start the presentation. I'm sharing my screen, so I hope you can see my presentation correctly. And as I expect this presentation today is that I didn't expect to lose the co-speaker of this panel, but nevertheless, I will try to stick to the original plans of talking around 40-45 minutes. And the floor will be yours after that to raise questions. I believe you can have questions. So something I wanted to mention as a disclaimer at the very beginning of this session is that I'm a person from Hungary, from Europe, as I usually say. I do comparative research, but this is only one option that people might, the one way how people might summarize artificial intelligence and the challenges of artificial intelligence for copyright law. And you are from a country which is an extremely important country with extremely developing and great economy. And as far as I know about Indian intellectual property, you also have a very developed intellectual property system. So you might have a totally different view. You might have totally different policy reasons for a different view. I'm here to learn from you as well. So I do my best to teach you, but I'm here, and please do your best to teach me as well in order to make me understand your country's approach to the challenges of artificial intelligence. As you might see, the original program shortened the topic for today. So it's artificial intelligence and copyright. But when I talk about this question, I cannot stand to add the full title of my presentation on the screen, which is From Leonardo to the Next Rembrandt, the need for AI pessimism in the age of algorithms. You will understand fully why I mentioned Leonardo and the next Rembrandt. And you will understand what that expression AI pessimism means when we enter already the middle of the presentation. But you will see that at the end, my point and my opinion regarding the artificial intelligence and copyright issue is that we don't need copyright protection for AI generated outputs. I'm going to drive you through my opinion regarding this question today. And then let's start. My presentation starts with a very interesting statement, which is, by the way, not a surprise. At least I believe it's not a surprise to anyone. Law is a fiction. Law is a fiction, which means that we humans create rules that we believe to be fair and that we believe to be ready and capable to regulate human society, including economy, including everything, including intellectual property law. So this is the starting point. And this is very important to highlight, in my opinion, because artificial intelligence, just like any other emerging technology of these days, is a challenge to the status quo, to the existing regime. So the main question that artificial intelligence raises nowadays is that whether we need to adjust to those challenges, whether we need to change the legal system, the legal fictions we have developed, let's say in a couple of centuries up until now. When we talk about technology, there shouldn't be any surprise that many of the technologies have disrupted the status quo. From player piano to gramophone and phonogram, we have witnessed the emerging technologies as early as 19th century that affected copyright law as well. At the beginning of the 20th century, a very important American composer, John Philip Sousa, who was the composer to plenty of American army marches, testified in front of the US Congress when he said, when I was a boy, in front of every house in the summer evenings, you would find young people together singing the songs of the day or the old songs. Today, you hear these infernal machines, so gramophone and phonogram, going night and day. We will not have a vocal cord left. The vocal cords will be eliminated by a process of evolution, as was the tale of man when he came from the ape. Of course, that might sound a little bit cynical, and of course, we all know that he was not right in the sense that we still have vocal cords. This is why I can talk to you. But he was totally right to highlight something. Technology has changed social habits and our daily routines. Nowadays, if a person is walking on the street and sings, we almost all believe he's crazy, even though that used to be the trend 100 years ago, because that was the way how could socialize and how we could communicate and enjoy ourselves. So things change, and technology had a leading role in these changes. And we could also talk about 20th century changes from the videotapes to CDs to iPods. iPods have already died. Downloading technologies of the internet and streaming technologies of the internet. So we are currently in a period which has, by the way, with an unexpected pace of technological development, an environment where we are not only heavily stuck to the offers of technology, but we are truly needing them for our daily activities and daily routines. Of course, the major challenges are coming from the direction of internet. And not only the historic internet of the 90s, but we are mainly talking about the so-called Web 2.0 period, where social networking sites, where platforms are offering the chance for end users not only to consume contents, but also to create contents. But Web 2.0 had not only effects on the amount, on the way of access and production of contents, but one of the major challenges of Web 2.0, I mean your activities online, my activities online, was the massive amount of information that we have nowadays. Artificial intelligence is partially here with us because of the massive amount of information we have out there. Artificial intelligence is probably the only way to deal with text and data, as we usually call them nowadays, which is available in such a great amount as of today that humans cannot deal with them anymore. Of course, technological development was not only beneficial for many, but it was detrimental to many, and especially some. Here I'm mainly talking about American movie and music and software producers, of course. And therefore, technology was not only a means for accessing contents, but also a way to limit accessing the contents. This is why we have digital rights management. This is why we have geographical limitations, so-called geo-blocking technologies out there. This is why content producers try to seriously control the way of the consumption of data. Unsurprisingly, for the last 10 years or so, civil society has heavily attacked any kind of trials to expand the scope of copyright protection on an international level. One of the most important examples, ACTA, Anti-Counterfeiting Trade Agreement, was also heavily protested against ACTA. People heavily protested globally. Of course, nowadays we are living in the age of the big corporations. When we talk about Alphabet, Amazon, Apple, and Facebook, they are the most valuable corporations out there. But of course, companies like Netflix are growing, and of course, technologies like blockchain grows extensively nowadays. And we can sum up something I try to use on my classes, I mean, undergrad classes as well, an image here. I imagine copyright law as I try to indicate it over there. I believe, and I will try to highlight it a little bit later on as well, there are three key actors to the copyright ecosystem: the authors, the creators, the technology owners, which are nowadays mainly the platforms, and the consumers, the society. And the red triangle tries to show the copyright system in general. What I believe about current realities is that we have overlaps, we have conflicting overlaps and supportive overlaps as well. So nowadays, I as a consumer can be an author as well, but I can be the technology owner as well. So I can publish my book for sure. I have my own blog, etc. But what is probably the most important issue here is that all of the actors can do things which fell outside of the scope of copyright law. Many disruptive or emerging technologies and challenges from them are outside of the current copyright ecosystem. This is what artificial intelligence is at the very moment. So this is where our problems arise nowadays. Very shortly, a few more slides about artificial intelligence and later on copyright as well. the idea of thinking machines or intelligent machines is certainly not new. People, especially British people in the 19th century, especially Ada Lovelace and Charles Babbage, have done considerable theoretical work to develop, and by the way, practical work as well, mainly Charles Babbage, to develop the thinking machine, not computers yet, but machines. They call them calculating machines, automatic calculating machines, wonderful things, and you would be surprised, but these are 200 years old things. Of course, when we talk about artificial intelligence, we usually think on computers and machines fed by electronic signals, so computers simply. And these important works were mainly done by both British and American people, but in the 20th century, and very heavily connected to the Second World War in this sense, to try to fight against the Germans with the help of coding technologies, etc., etc. Alan Turing, a person that you certainly have heard about, is one of the key names. He died quite early, so his research is somehow limited in terms of time at least. So this is why many people say that Claude Shannon was another father of modern artificial intelligence researches as well. Nevertheless, when we talk about artificial intelligence, you don't need to talk about such historic examples. We talk about these, Siri, Alexa, those kind of tiny robots in museums that help you to go through the museum, what to see, what to know about an image, or Neon, which is an artificial intelligence technology or software fed visual depiction of information, human-like depictions, very interesting. So, and Google Translate, of course. Google Translate is one of the most handy artificial intelligence, or Google Maps, etc., that we use nowadays. But of course, artificial intelligence is present in almost every sector of economy nowadays. So, I will shortly talk about artificial intelligence's definition yet, but that will be with a focus on copyright already. So I try to start my main points here. And the main point, something I have already highlighted here, is nothing else. Are we ready for a paradigm shift? Are we ready to rewrite or copyright fictions in the light or in the wake of the outputs generated by artificial intelligence, machines or software, whatever we say? That's the real question to me. So this is something I try to address here. And I believe there are no more than two chances or options to choose from, the red or the blue pill. I call one of the pills as AI positivism, the other one as AI pessimism. I call them this way, but there are plenty of other expressions. So if you just read about artificial intelligence and key options, there are plenty of other expressions. I call one of the options AI positivism for the simple reason. People who I believe to be positivists believe we shall give broader protection for AI outputs. AI pessimists like me believe that the current existing intellectual property regime is not ready to embrace artificial intelligence technologies, at least not on the protection level. So no protection shall be granted. There might be other questions, of course, I will highlight them at the end of the presentation, but I believe, and this is my key argument, we shall not protect artificial intelligence outputs. So take one of the peers, of course, at the end of the presentation, you can criticize me as well, or you can agree with me. You don't need to do any of these. So, artificial intelligence and copyright law. In order to make my points even more clearer, let me use a couple of sentences and minutes on the definition of artificial intelligence. But you will see I am unable to define what artificial intelligence is for one simple reason. This is not a legal question. This is much more an IT question, and there are plenty of options. As you might see it on the top of the presentation, there might be different angles to look at artificial intelligence. We might look at AI as a system, as an entity, or as a full science or scientific field. Some people look at AI as a software versus a hardware question. Some people differentiate between the strength, between the abilities the independence of artificial intelligence, and they call them strong, general, or weak AI. I have a couple of quotations on the screen, and for your consideration, I have already sent my presentation to Vishwa, but I'm very happy if he shares my presentation with you, or if you want, you can contact me. You will see my email address. I'm happy to give my slides. So you don't need to type down everything from my presentation. You can get my presentation and just look at these notes. At the same time, you will have a link to my article on this question. All these citations are included in the article point. So you can get all these information later on. I finish here with a highlighted sentence on the bottom of the page. Defining AI is not an easy task. And again, I add my comment here, and I don't believe it's a copyright lawyer's task to define what artificial intelligence is. What a copyright lawyer, however, has to do is to look at the functionality, look at the real activity of artificial intelligence, and for that purpose, copyright lawyers might have their own perspective. And that perspective is nothing else than what contribution artificial intelligence has to the outcome of a creative activity, be it, by the way, invention in the patent law field, or be it creative artwork in the field of copyright law. The leading question is, what is the role and how broad is that role of machines, software, etc. in the creative process? We can simply say that based on historic examples, machines have become creators, or will shortly truly become creators from tools. 200 years ago, machines were only tools to calculate. Later on, machines became assistants to create something like Photoshop, or like Word, Microsoft Word, with which you can create your own stuff. It's not only a mere tool, because Microsoft Office can also assist you to reach a higher level of quality and consumer happiness, to say it this way. So we have already seen in the last couple of decades that artificial intelligence, machines, software, etc., can easily sidestep their mechanical function. And when we look at the stages of creation of or with AI, we can differentiate between three main steps. Coding, which is simply the creation of the software. This is simply human-made activity as of now. That's clear, even though there might be chances to change this situation. The second step is the so-called input, training, or machine learning step. This is something that machines can already do. Machines are originally educated what to look at, but machines are nowadays able to select what to read yet. And that's a very important thing. And the third step is the output. The output, what is the visible creation, like a painting, like a novel, like a poem, etc., or an invention, by the way. I will argue that as long as a machine is an assistant, forget about tools, okay, they are at least assistants nowadays. As long as a computer, a software, an AI remains an assistant, the copyright protection shall be assigned to the human behind the machine. But I will say, as soon as the computers became the sole generators, creators of the outputs, then we will lose the connection between the human contribution and the final output. And therefore, there's no reason to provide protection for the computers. So their copyright must stop. This will be, introduced in my presentation today. But very quickly, AI is there everywhere. AI is present in movies, music industry, arts industry, literature, and news industry. Only a few examples. Of course, many of the movies are about artificial intelligence, like Matrix or Space Odyssey. Some movies are representing the concept of living and feeling machines, like Ex Machina, or a very interesting South Korean romantic TV, I think that was a TV show, I Am Not a Robot. Very funny. Actually, the story of the movie of this I think, no, it's a movie. The movie was very interesting. A young professor, look at this guy. He's a young professor in Korea. A young professor was required to test an artificial intelligence, whether it's enough human-like. But because the creators of the artificial intelligence feared of the negative outcome, they ultimately decided to replace the machine with a real human, flesh and blood female. Of course, they fell in love, but the male professor had the belief this is a machine. So the story is very funny. A human falls in love in a female who was thought to be a machine. So it's very nice K-pop stuff. But of course, plenty of other movies are about thinking machines as well. One of my favorite movies is The Bicentennial Man with Robin Williams, the late Robin Williams, where the robot created clocks and also played music. But to use another example, there's another Hollywood stuff, but it also starred Dept from India, a very interesting, I would only say interesting movie, Chappie. But nevertheless, these are movies and ideas. But artificial intelligence is there in the movie industry in flesh and blood as well. The first ever movie with an artificial intelligence robot in the main leading role, is under production. So a machine will play the main role of a movie. Wow, okay, we'll see whether it will be a good quality, but we are living in this age. It's the same in music. We have artificial intelligence created music, experimentally music intelligence, or for Beethoven's 25th anniversary, an artificial intelligence was finishing Beethoven's unfinished symphony. IMAS or IVA are also examples for that. And some people have also created hardware to the software musicians. They are called compressor head, I cannot pronounce their name. Very odd and very interesting heavy metal music from heavy metal, by the way. AI is with us in art as well. You can see images about AI created outputs, or at least the machines there. Here is eDavid that can create any kind of images based on machine learning. This is an artistic output by a machine based on some basic software language to create a dream-like image. This on the bottom is the portrait of Edmond Bellamy, which is the first ever sold painting sold on auction for more than, I always forget, but for more than $600,000 or $500,000. Crazy. And it still looks bad. Nevertheless, it values a lot. And here is the best example. This is the next Rembrandt. This is not Rembrandt, but this is fully Rembrandt style. The creators of the next Rembrandt algorithm fed all of Rembrandt's paintings into the memory of the artificial intelligence and gave instructions to the artificial intelligence to paint a white male person with a hat, with beard, with this typical Dutch clothes, etc., etc., dark background, because this is typical Rembrandt. And look at this. This looks nice. This looks like a Rembrandt. I would be very happy to put it on my wall. It's just fake, not Rembrandt, at least. But this is what AI can already do in the art industry. We have AI in literature as well. Literature written by AI, and of course, literature written about AI. I'm not sure whether you like Dan Brown or not, but Dan Brown's latest book was about artificial intelligence. It wasn't a big surprise. After 20 pages, I knew that and I don't tell you who is the bad guy, but after 20 pages, you will notice who is the bad guy, or at least who is the strange guy of the movie. It's about AI, practically. But this is a book about stories written by Brutus, stories written by another machine. Ray Kurzweil, who created Google, at least the idea of many things connected to Google, also had its own cyber art website. My favorite are those haikus that are written by machines. 3 lines haikus, but written by machines, and they are good. Very interesting. And finally, AI is in the news industry. There is Project Debater, which actually thought itself during the debate with humans. And ultimately, audience concluded that the machine was a better debater than humans. Associated Press applies artificial intelligence to create news on sports events and stock exchange information. Here is Xinhua Television's artificial news reporter. He's a flesh and blood person. He was recorded, but artificial intelligence moves his mouth ultimately. And I didn't indicate it on the screen, but we already have a decision, court decision from China that said that Tencent has copyright over the news reports written by an artificial intelligence plus a human group of supervisors. Very interesting developments to this field, I would say. But jumping to the real question, do we need to change system? I still believe I have to highlight a few notes. Open questions. I don't believe this is a yes or no issue. Okay, this is not an issue where you can simply say, oh yes, we need protection for AI. We need no protection for AI. So let's go through the open questions. First question, will future AI algorithms need any human intervention at all? Because if yes, so if we need humans, then there's no real question to change the copyright system because we have humans in the system and copyright protects humans. Admittedly, we seem to need humans yet at the very moment, at least for the coding progress or process, and as the Chinese case indicated, in the overseeing of the output. But things might change. Some corporations might show the way for machines to go out to the streets and exercise their practices alone. So things might change later on. So put it this way, I can imagine that in 5 to 10 years, easily some corporations will let their AI work on their own and let the machine let the machine be separated from humans. So this open question is somehow solved in the sense that yes, theoretically it will be possible. Next question, will there be any market or need for AI generated content? This is a very crucial question because whatever romantic copyright law is, it's of course about money. You can live from copyright if you can sell your work. If you are only working for yourself, like, by the way, Vincent van Gogh did, or one of the greatest Hungarian painters, never ever sold any paintings in his life because no one believed he's a good painter. It was only Pablo Picasso who said on one of the auctions that, hey, I never knew that there is another genius. So you understand, he thought himself to be a genius and he believed the Hungarian guy was a genius, but no painting sold. Nevertheless, if there will be a market, consumption, a need for AI outputs, there will be, of course, money in it. And there will be financial incentives in the system as well. And as you have seen, the portrait of Edmond Bellamy was sold on an auction. Of course, this is still a rare example rather than the general rule, but we have the chances for that. And next question, then we reach IP. Is there any real need to provide IP protection? And if so, is it or should it be patent, trade secrets? Should it be, by the way, simply contract law? Why copyright? Why should it be copyright? A couple of years before, there was a report from a person at the European Parliament who said the statement on the screen: there is no need to overhaul the whole body of literary and artistic property law, copyright law, but merely to adjust it in the light of the autonomous robot's new future abilities. Is it true that we only need to adjust copyright law to a new challenge? Isn't it a little bit more troublesome? Or to show it here, there might be plenty of certainties around AI and copyright. AI programs are protected by computer programs protection, software protection. AI datasets might be called a database, at least in Europe. Human contribution might easily lead to authorship. But if you look at the other side of the screen, you might see that plenty of open questions remain. What is the justification for protecting AI outputs? Should we give exclusivity to a computer program for the protection of an output? Do they have personality? Shall they have authorship? Do they have, or can they have ownership? Are those outputs original? Shall we give them economic or moral rights? What should be the term of protection if a software never dies? Humans at least die at some point. Limitations and shall limitations and exceptions apply? Shall we apply digital rights management? Who is liable if an artificial intelligence infringes whatever rights? Copyrights, human rights, personality rights, data, so data protection issues, etc. Who is liable? The machine. Are you going to execute the machine for doing something bad, etc.? Do machines have standing? Can they go to court? Can they be sued? Can they pay from their own wallet? So who pays the remedies, etc., etc.? There are plenty of open questions. And to use the sports language of American football, I like American football, and there is a sentence according to which nowadays with computer technology, the referees can overrule their decision made on the field. If they look at the screen, they might change their decision. Nevertheless, the rules in NFL say that changing the ruling on the field is only possible if there is indisputable, conclusive evidence that the decision on the field was wrong. So to use this sports language, I would say, as long as there's no indisputable, conclusive evidence to the fact that AI and AI outputs deserve protection, either in exchange or against human creators or besides human creators, I would say no changes are needed. For that purpose, let me very quickly, because I think time is going quickly and I don't want to misuse my time, let me highlight my key points regarding my pessimism. You can see a Greek temple on the screen. I love this metaphor. I believe that Greek temples are great to highlight what copyright is. Greek temples have their own foundation, so the stairs. Copyright law has its own foundation with its history and incentive. The Greek temples have their own pillars. That was quite artistic. There were three main types, Doric, Ionic, etc. The three main types of pillars. Copyright has its own pillars, from authors through subject matter to term of protection, etc., etc. And there is, of course, the most beautiful part of the Greek temple, the top, that Greek people call tympanon. This is beautiful, by the way. If you have any chance to see the few surviving tympanons of the globe, look at them, beautiful. I believe that's the most beautiful part of copyright law, that's the practice, exercise and enforcement of copyright. But my key points here are indicated with the extra words and the line or arrow at the bottom. I say that some of the most crucial elements of copyright law are extremely non-flexible, and some parts are extremely flexible. The term of protection have already changed several times in the last 300 years. Now it's life plus 70. Historically, it was 14 years, 14 only. On the other hand, without wasting time here, I believe the concept of authorship, moral rights, and originality, at least these three, are extremely non-flexible. They are heavily stick to human nature and human, the concept of human itself, history as well, incentives as well. But we, at this point, cannot escape looking at the concept of human authorship in copyright law. Because time is going by, I'm just highlighting a few more slides, not talking that much about that. Again, you will have my slides, and I wrote about that as well. I believe copyright history evidences that the center of the copyright development is always the human behind the work, of course, with a serious focus on social development, but human society in general. So more humans at the same time. Incentives were developed, various incentives were developed in the course of time by German, French, British, American, etc. People. And these key theories are indicated on the screen here: personality, labor, and the utilitarian theory. I argue in my paper, and here I also try to highlight that I don't believe that any of these theories can support the protection of AI. Personality theory and labor theory are heavily based on the human activity. The labor theory and the utilitarian theory at the same time focus mainly on incentivization and rewarding the authors. But as Daniel Gervais said in one of his articles, if an AI machine is programmed to create, it requires no ex ante legal incentive or ex post reward for doing so. Actually, computers need no hamburgers or Coke to work. They just work. That's so simple. So to sum it up, as long as we don't find any other extra incentives, I don't believe there is any reason to change the existing regime as well. Authorship. The concept of authorship is not defined by international laws, but generally both in Europe and in the United States, and I would say everywhere around the globe, authors are usually treated to be humans. Of course, historically, the human authorship concept was at least partially broken in many countries. Americans have developed their own work made for hire concept, according to which copyrights initially vest in the hands of the corporation, in the hands of the employer. It doesn't mean that the corporation is the author, but the corporation has the ownership interest initially over the works. In Europe, we have a little bit different system with respect to work made for hire, but we in Europe have also changed the sidestep the question of authorship in a couple of questions related to so-called related rights, sound recording producers, film producers, database makers, etc. Corporate interests are also served in Europe. But these neither mean that the initial author loses his author status. A couple of years ago, a significant case emerged in the US again. I'm not surprised, sorry Steve, but I'm not surprised to say that sometimes the craziest cases come from the United States. There was a case where, by the way, an American photographer left cameras outside in the Indonesian jungles, and the macaco negra found the machines and started to make selfies. This is a true selfie made by a machine. Took the machine and clicked it several times. Wonderful image, by the way. And then an American, I think association, PETA, tried to acquire the copyright ownership over the photographs made by the animal, claiming that we use the money pouring in from the use of this photograph for the benefit of animals. But of course, they had no standing in this case. Why? Because the animal cannot be a creator of any copyright at all. In any case, people like to use the monkey selfie case as a tool to highlight that why not giving authorship interest to other than humans as well? So maybe monkeys as well, maybe machines as well. I don't believe this is the good solution. And as Chris Bukowski said it at one point, constitutionally, copyright law requires authors. It cannot simply kill them off. Oh, sorry, I edited my presentation. Originality is another concept of copyright law. Originality is nevertheless heavily connected to authorship, subject matter, and creativity. You cannot create any original work of expression if it's not an author's own intellectual creation, if it's not connected to existing or loosely regulated subject matters. And creativity is also, at least in many countries, a prerequisite of protection. Of course, as some people highlighted, whether a computer can be creative is ultimately a philosophical question. I agree. This is not only the field of copyright law, but copyright has its own standards. For copyright, creativity means something special, not the same as what it means for philosophers. And sum it up, at least this point, copyright is not an investment protection scheme. We shall not necessarily give rewards for someone who invests. It's not always necessary in copyright law. That might be the field of contract law or trade secrets or whatever, but not copyright law. And very shortly, there are moral rights in many countries. They do not apply in this respect in the United States, maybe only for visual art outputs, but it's a limited system in the United States. But I would say we cannot simply give moral interest to machines if they have no human nature. Someone muted me. I don't know what happened. No problem. In any case, I would say, even though machines might be able to think creatively with some kind of moral rights interest in their mind, so how to publish, when to publish the content, I don't believe this is the good form and the good tool to give into the hands of machines. Very shortly, this slide. I am only one end of the spectrum. My default position is that AI outputs must go into the public domain to benefit the full society, the whole society. Not everyone believes so. Some people say, like Japanese people, we shall have a non-human created IP regime. So they would eliminate the human requirement. Some people say we need sui generis rights for AI investors. Some people say we have to expand the database maker sui generis protection for AI creators. Some people say, why not using the neighboring rights regimes for AI corporations? Why not creating a new disseminators right? So forget about the creation side, focus on the marketing. In the UK, New Zealand, Ireland, South Africa as well, they have a very interesting rule. I'm not sure whether that's the same for India, so you need to teach me. Some countries have a so-called computer-generated works regime, but that regime is mainly designed to support those situations where it's very hard to detect the human behind the machine, and then, nevertheless, the person who had the closest connection to the creation is granted copyright protection. There is only one decision from the UK in the last 30 years regarding this rule, so this doesn't seem to be the best option. Many Americans say work made for hire must apply. Some people say, oh, reduce the copyright term, not life plus 70, but only 5 years or so. And my favorite one is that we should give authorship interest for the machines, but immediately remove their ownership interests through Creative Commons licenses. So it's a very interesting system, giving and taking away at the same time. But there are many options, as you might say. This is why I say, remember, you need to take a pill. But of course, practically, there are plenty of pills that you can take. And maybe at the end of this presentation, you need a lot of painkillers. But in any case, there are many options. And summing up my presentation here, I have a couple of quotations, again, long quotations. You will have my slides, you can read them. Many people, of course, try to stress that, wait a minute, guys, life changes. We have to live with that, and we have to adjust to it. As one of the most important 20th century philosophers from France, by the way, Foucault, said, the author function will disappear. So forget about the author, forget about the creative genius behind authorship. Another person said, if copyright regime did not apply, such works, AI-generated works, could arguably cause market failures. Some people say encouraging the production and distribution of new works, irrespective of the manner in which they are created, might be a good tool for a utilitarian society in general. Nevertheless, I like these quotations much better. Sam Ricketson, one of the most important international copyright lawyers from Australia, said, people rather than machines must be protected. Lev Grossman, in a very important article published in the US said humans and humans only must be protected. And still, the most important quotation, I believe, is coming from Daniel Gervais: human progress should serve as a normative guidepost. What copyright law has tried to do in the last 300 years was, of course, giving some protection for individual creators and supporting the society in general, education, research, cultural preservation, etc., etc. But in any case, the normative guidepost of copyright law used to be social, cultural development. I believe we shall not change that. Shortly, summing it up, keep your eyes open because this is an extremely hot debate nowadays, especially in the European Union, but there were international conferences only dedicated to this question, protectability. I mean, protectability of AI output. For example, by the AIPPI, the WIPO has run 3 consultations so far on the very question of AI outputs, not only copyright, but patent law as well, and many other questions. You might see an image over there about me. I had the privilege to speak up at the WIPO's global event to tell my opinion in 2 minutes. By the way, I succeeded because I only used 1 minute 54 seconds. I had no more time to talk, neither did anyone else. And I finish here, but here's a link to a paper I already finished. It's only under publication, which is a little bit frustrating because it's already under publication since 9 months, but it will be out very soon. But you can access it through SSRN. Just look for that. It will be out in a couple of months, I hope so. And of course, thanks for your attention. I hope you enjoy this presentation. And now I already saw that there are some comments in the chat forum, so I'm at your disposal to answer any of your questions. But before doing that, guys, sorry, my battery is low. I have to plug in my computer. Just a second. And I'm already here. Okay.
Okay. Thank you, Professor Peter, for such an enlightening session on artificial intelligence and copyright. I can just say one word before I take up the questions out here, that from 1956, we have traveled a long time from John McCarthy, who has tried to talk about the artificial intelligence and its prominence. But if I can highlight a book I was just going through, and I was just talking to my fellow colleagues who are teaching IPR, the Creativity Code. It's by Marcus du Storey. And he just argues, I would be requiring your comments on it as well. If you talk about Alan Turing, he died in the year 1954, and 1956 onwards, we started talking about artificial intelligence. And before 56, we were talking about the possibilities of algorithm. But now we are talking about the creativities of algorithm, what they possibly can do. So do you think it's a progression or a transformation in the technology? Because you have used the word multiple times, the disruptive technologies. How do you contrast these elements when we talk about the creations?
Sure, very good point. A few comments. I think I used the word disruptive rather than destructive, which is a little bit different in the sense that here disruption tries to mean that, and of course it's a biased expression, it intrudes into the status quo. And I don't like this expression either. So I am truly considering changing my terminology as well and trying to, and I will most probably follow, even though copyright lawyers like to use disruptive technology because the majority of copyright lawyers are conservative, not me. But emerging technologies is the emerging expression nowadays because it seems to be a more neutral. Indeed, it tries to highlight the progressive nature. So your question is very good. And another comment yet need to be added here. You mentioned 1974, 75, this period. But interestingly enough, the first ever report on machines, artificial intelligence, and copyright came from the United States from 1961. As early as 61, American people, by the way, US Copyright Office, I mean, top guys, said, we have to think on this question sooner or later, because machines will take over a couple of roles that humans had. But answering your question, and I cannot deny, you are totally right. This is truly a progression. What we have seen is that in let's say 50 years, 60 years, who cares? I mean, again, it's a nuance in some sense. We have reached an incredible amount of development in this field, but this is not only in this field anymore. This is our society. If you just think on big corporations, again, Google and other corporations, they use AI on a daily routine. You guys, even if you don't believe, you use artificial intelligence on a daily routine, and services you are using are based on artificial intelligence as well. In the United States, police regularly uses face recognition algorithms nowadays. It's part of the process. With a few serious problems, nevertheless, but it's a totally different thing. And this is why, Vishwa, I must admit, I'm not sure I am on the good side of the issue. A quick note, I am a very progressive guy. Those who know me know that I am, well, it doesn't matter, but I'm a liberal person, but I'm very much in favor of social development. And this is why I feel myself also shocked how conservative I am against artificial intelligence. But I cannot deny, this is my feeling, so this is what my paper is about. But I know that science develops always with disruptive thinking, with people who try to challenge the status quo. Oddly enough, my position, what I presented here, is that the protection side shall not be amended. I didn't mention it in my presentation because this the second step of my AI research. I nevertheless believe that AI corporations, shortly summing up them, must have the special chances, rights, limitations, and exceptions for machine learning activities. Or put it this way, even if they don't receive copyright protection for the outputs, they shall never be sued for making better and better AI algorithms and teaching the machine itself. Very simply, because we humans cannot do it anymore. I was writing this paper, for example, for around, let's say, half a year. Of course, I had other things as well, so this is why it took a couple of time. And you see it's in the press for 9 months already. I read over 150 papers, or approximately 200. This is probably the daily output in AI research, 200 papers. I'm dying. So in the last 9 months, I have felt that I'm an old-aged man in this research field, because whatever I say is outdated. Of course, not fully, because I luckily could write my paper, not theoretically, but on a higher level, abstract level. But Vishwa, wonderful question, yes, and I truly believe there is a progress. And this is why I also believe that I might need to reconsider myself in 10, 15 years. Who knows?
Okay, I would take a follow-up question by Dr. Chintan Pathak. He is a well-known person working in the field of technology and law in India. So he's asking about what is your opinion regarding the legal obligations under Creative Commons?
So the question is only to Creative Commons or AI and Creative Commons?
He's asking about Creative Commons, and you can pair it up with artificial intelligence and Creative Commons, and you can.
Okay. It's a long story and a hard question, of course. I guess those who already know about Creative Commons know that this is somehow, of course, not a pirate movement, but this is an atypical movement stemming from the United States many years before. Many great names including, and one of the founders was Lawrence Lessig from Stanford, who also represented, at least advocated some people in famous American Supreme Court cases as well. They were fed up with the fact that the term of protection is such an extremely long thing in the United States, and of course the whole regime in the United States is proprietary oriented and corporate oriented, that they wanted to create a new system that allows for creators to choose between this or that way to exercise their rights. Creative Commons is a mixture, a crossover field of copyright law and public domain, because it means that under certain circumstances and under strict contractual limitations, you can give absolute freedom to end users. You are not giving up your copyright, but you give up some kind of activities like full enforcement of rights, or only you enforce the attribution of your name, right, etc., etc. And in some sense, this is a wonderful idea for many. Wonderful idea in the software industry, in the music industry, in the book industry as well. Creative Commons license is heavily used by scientific publications, in law as well, like there's a journal I regularly publish in. They have, of course, they have various licenses. CC is the default rule for them. But this is not good, totally not good for big corporations, because this is not paid. Creative Commons is generally a free of charge license. With artificial intelligence, it's a very nice question whether we should bring output into Creative Commons licenses. But as I try to highlight, the first step for that would be we accept that AI outputs have, and AI in general, have personality, have authorship status, have rights, have standing, have the chance to sign a contract. I think this is the first step that we cannot truly sidestep. If at some point we will have a system where the corporation is granted some kind of rights, why not Creative Commons? Again, as I said, this has its own features that bring it closer to public domain as well. Not public domain, but public domain-ish. So I think the question is very, very nice. As soon as we can surpass the challenges or meet the challenges of the protection issue, then maybe Creative Commons will be a practical solution. Thank you for the question.
Great. We do have a question from one of the faculty members of ours, Ms. Taruna Jakar. She's writing to us that the Indian copyright, it's a bit lengthy, so you have to listen to it properly. So she writes that the Indian copyright legislation provides definition of author. And this definition states that in relation to any literary, dramatic, or musical or artistic work, which is computer generated, the person who causes the work to be created, they would be having the right. Now, in light of this definition, is not possible to draw an analogy of agency being presented between the AI and the human being. And you try to protect such authorship through the AI. What is your opinion about it?
Okay, my opinion is that I have already learned a lot from you guys. I was only guessing because I know that India has very close connection to the British copyright system as well. So you also have, I have this kind of concept that the British have. I have to change my presentation then, and I will happily do that after this, after we finish here. My comment on the British regime, including the Indian solution as well, is that now you guys can easily see what I wanted to mean by fiction. This is a true fiction. Not science fiction, of course, we can call it as well. It's not, of course, legislative fiction. But this is what the British tried to reach in some sense. Survive the challenges and problems surrounding the uncertainties regarding the causational link between the teaching and the output. What I wanted to say here is that I must learn more about India, but I know about South Africa and the UK that there are only altogether, so one in UK, one in South Africa, there are only 2 court decisions regarding this kind of provision in the last 30 years. I'm not sure whether India has decisions, so you should teach me. If yes, I would be very happy to read them. But very interestingly, not even in the UK, which is somehow one of the key AI developers of the globe, has ever used this rule for AI outputs. So this fiction, although literally seems to be applicable, in some sense at least, nevertheless doesn't seem to be practically functioning. And it sounds like a paradox. The only legislative solution at hand doesn't seem to be applicable, which is very interesting. Maybe we can call it funny as well. But very good, very great comment. Thank you.
So one last question we have from Dr. Kunal Kishore, who is a faculty with us. He writes that the research in artificial intelligence since McCarthyian era led to increase of state surveillance and loss of democratic rights. How do you see this development as it increases the coercive power of the state?
Wonderful, wonderful question. And this is why I always say, well, I try to highlight it as well, that I don't need to define what artificial intelligence is, because this is not a copyright lawyer's task. The question makes me feel that artificial intelligence in practice is totally not a copyright issue. It belongs to ethics. Artificial intelligence will heavily be used in economy, in warfare, in policing, etc., just as you said. And this is why we have to raise not a copyright question here, really, but another social question. Do we really need to have machines to police us? And this is, of course, nothing about the Terminator movies. I mean, it's just, I mean, we humans fear from every unknown thing. Guys, a quick note, and then I continue my answer. Sorry, I am just such kind of person, having plenty of ideas. The first ever time I made this presentation was in Bournemouth last year, actually 1 year before, in February, actually, or probably almost exactly 1 year before. I'm not sure whether you have known that, but the author, Mary Shelley, of the Frankenstein story was buried in Bournemouth. And we call this kind of human behavior as the Frankenstein effect. We fear of the unknown. We fear of the strange, or of course, Frankenstein looked bad. Artificial intelligence doesn't look anyway. Well, even if it looked like Arnold Schwarzenegger, he looked, I don't know how. But we fear of the unknown. And forget about that for a second. Of course, some other bright people like Isaac Asimov has written a lot about the codes, the rules, the statutes, the laws, we call them laws, the laws of the robotics. According to the laws of the robotics, a machine shall never hurt any human. As long as a machine can be educated properly, they will never hurt humans. Forget a second about Terminators. But still, we humans use artificial intelligence. We use artificial intelligence for whatever stupid purposes. Again, in the United States, facial recognition is heavily used by police. According to official information, the system's efficiency with respect to white criminals is over 90%. 9 from every 10 people are easily caught by the machine. The efficiency with African-American accused people is far above 50%, closer to 30. So it means that 7 from every 10 black people brought to the police are not criminals, which is a shame. I'm not blaming anyone. So this is still a step that have to be get over. It has to be learned. But what I want to mean, it's still used. We humans still believe that these machines are good for us, even if plenty of African-American people are arrested on false positives. It's bad. And answering the question directly this way, I am personally in favor of dealing with artificial intelligence and ethics first, whatever amount of years it takes. Many people claim if we don't act quickly, I mean, trust me, even European policymakers say, if we don't act quickly, Chinese will be the first. Okay, I'm not sure who will be the first, but I will certainly not be happy to live in a world where machines, artificial intelligence, by the way, certainly controlled by humans, control our lives. But this is my human, Hungarian, liberal, stupid, whatever you call it, opinion. But I would certainly say ethical AI is the magic keyword.
Great. Now, as you have brought in the Hungarian perception of it, we have one last question from Ms. Sureka Talari, who is a faculty again. She's asking that, are there any reasons or are there any areas where the Hungarian government didn't promote AI to protect the people's right? What is the take of the government of Hungary with regards to the employment of AI?
Tricky question, and I think the answer is or will be quite short, even though I will probably speak more than 1 second. We have an AI strategy. The AI strategy envisages huge GDP growth from artificial intelligence. And the document, which was officially published last year in June, has a date of 2019. So they don't even know what they talk about. They don't even know what and when they published. Okay, I don't want to be too critical. We have a strategy which might be good for some corporations, touches upon some artificial intelligence development, research as well, and practice as well. But I would simply say that as we are members of the European Union and the European Parliament is extremely active nowadays on AI, we have a high expert group on the field, including both philosophers, practitioners, businessmen. Interestingly enough, only one lawyer, but it's not an issue. And we have parliamentary committees publishing almost every week a new AI report on everything, really, truly. We also already have an AI and IP report, which is quite shady, but directs us to the real problem-raising questions in AI. Do we really need that? But they seem to be a little bit biased. Again, they somehow say we need to be quick, otherwise others do it quicker. So the answer to my to this, by the way, very nice question to ask about Hungary is that we are not the #1 policymakers of the globe, but we have some ideas. The problem is that this strategy and actually the body, the organ, well, it's a body that made this strategy includes no lawyers, and that's a problem to me, businessmen, but it's not enough, I would say.
Great. So there is one line of appreciation coming from Professor Stephen Barnes for you. He's writing that, thank you, Dr. Peter Mezei, for your brilliant presentation. You covered for some or many of us, the present company especially, a very complex area and really framed not only the legal issues, but the moral, ethical issues, assuming that they can be separated. Truly provocative, and your passion for your expertise area proves and explains your stature in the field. Truly inspiring. Thank you, Steve. So these are wonderful words coming from Professor Steve Barnes. And not only that, I just got an email from one of our participants. She's Miss Athira. She's writing from NUAS, one of the national law universities in India. That thank you for enabling for this wonderful program. She has been delighted to hear you out. So with those words, we have come to an end of the session. And now I would request Prithviraj Singh Zala, one of the students of Institute of Law, Nirma University, to present the vote of thanks for you officially. Prithvi.
Thank you, sir. I, Prithviraj Singh Zala, on behalf of Institute of Law, Nirma University, present a heartfelt vote of thanks to Professor Peter for this insightful address and his work regarding the contours of artificial intelligence and copyright. Artificial intelligence is radically altering the way in which we work, live, and also create literature, music, and art. And with this great potential comes several legal policy problems and challenges. And it was indeed a great opportunity for all of us, as well as a learning experience, to hear about the same. I sincerely hope that today's thought-provoking session will surely make us more curious and ponder upon this issue. I'd also like to thank our Director and Dean, Professor Purvi Pokhariyal, and Professor Stephen Barnes for providing this opportunity, as well as Professor Bishwa sir for moderating today's session. I also lastly would like to thank all staff members who helped coordinating today's session. Thank you very much.
Thank you so much. Thank you, Purvi. Thank you, Professor Peter, and thank you, Professor Barnes. Have a good day.
Thank you very much for having me, and enjoy your wonderful International Month yet. I believe you have wonderful programs, and including one with Steve from next week throughout the remaining 2 weeks of February. So enjoy that. Thank you very much again for.
Thank you so much, and hope to see you in the campus very soon.
I hope so. Thank you.
Same here. Have a good day.